Good morning. We are on the record in the 89th District Court for the County of Sheboygan. We are providing public access to our criminal docket this morning, both in the courtroom and also online via live stream. And looks like the Galaxy S23 Ultra. Are you Mr. Waly?
Yes.
Alrighty. And this is Mr. Keogh. You're representing Mr. Waly, is that right?
I am, Your Honor, and Mr. Waly and I are here for an arraignment this morning.
Okay. And have you had a chance to review the complaint with him?
I have, Your Honor. We've reviewed the complaint and the charges. He understands the nature of both accounts against him and the maximum penalties. We will waive the formal reading and ask the court to enter a plea of not guilty.
All right, well, I'll enter a plea of not guilty as to both counts. Mr. Waly, I won't read the allegations. Just advise you, count one is a charge of wildlife conservation violation. It's a 90-day misdemeanor and a fine of $200 to $1,000 and restitution based on the animal and action on your hunting privileges. Count two is an allegation of hunting using another's license. It's a 90-day misdemeanor and or a fine of $25 to $250, cost of prosecution, and action on your license and hunting privilege, your hunting privileges license. All right, and you have the right to a trial and to counsel, and you are represented by counsel of your choosing. We'll schedule this for a pre-trial conference on April 11th at 10 a.m. And as to bond, Mr. Keogh?
Mr. Waly is a one-time resident. He's not a flight risk. This isn't a public safety offense here. We would just ask for minimal bond and personal recognizance, Your Honor. Thank you.
Ms. Miller, people's position as to bond.
Thank you, Your Honor. Mr. Waly is 43 years old with an address in Sheboygan. I do see 3 prior misdemeanor convictions. The most recent, it appears, is in 2017, and those are driving and alcohol related, so nothing similar to the charge that we have today. He does have a retained counsel and he's appeared, so I don't have an objection to a PR bond with standard conditions. Thank you.
All right, we'll set it at a $500 personal bond, so you don't have to post that, Mr. Waly. That would just be an amount you'd forfeit if you don't appear. And I'll just have it be standard conditions, no special conditions. So that just means you have to show up for court. You can't leave the state without permission. You have to let us know if you change your address or phone number, and you can't break any laws of the state of Michigan or any subdivision thereof. All right, anything further, Mr. Keogh?
No, Your Honor. Thank you very much.
All right, thank you. Have a good day, Mr. Waly.
Thank you, too.
Off the record to Mr. Gilbert's written. All right, we're back on the record, and we have a status conference for Ms. Sprague. And she's connecting her audio here. There we go. All right, so up next, we've got People v. Beth Sprague, filed 1-662 FY. And this is set for a status conference for the status of treatment for competency issues. And Mr. Gilbert, have you received any updates on that? Or
I have not, Your Honor, and we just asked for a status conference so it'll continue to be monitored.
All right, and Ms. Sprague, we've been setting this for a status conference about every month for waiting for updates from the treatment facility. The last report we have from them is in January. I think by statute, they're supposed to give us one every like 90 days. We've just been setting this every 30 days just to keep track. So I'll continue this for a status conference on April 11th at 8:30 a.m. And we should have the 90-day update report from them at that point, okay?
You've been waiting for this, Your Honor. In all due respect, I don't think I deserve I'm a single mother with full custody of my children. I have an 18-month-old and a 6.5-year-old. And they already my oldest went through CPS for 3.5 years already. She's staying with her grandmother right now. She's in school. And I also have HUD housing. I've been paying on my house this whole time that I have been here, $200 a month for my Social Security. I am an outstanding citizen. I've been grooming your trails even for 5 years now. I live in Mackinac Apartments. I've been dealing with this for 18 months. I went to an arraignment in August of 2021 for this. It was already Mr. Gilbert, with all due respect, not to speak on your behalf, but he did put a judgment. You guys entered a judgment on my behalf while I was in Saginaw Psychiatric Hospital in either September or October of 2021 with agreement there was to be no jail time if no trouble within a year, and it's been 18 months now. I think my year is up.
All right,
It
Ms.
was
Sprague.
supposed to be expunged from my record and no jail time. And I did 9 months in jail before I got here. And I've been here over 6 months. I've been here since September 7th from your jail. I missed court on April 5th of last year, which is what set off my IST.
All
And
right,
I was
Ms.
in your
Sprague.
jail at that time. Sorry, go ahead.
That's fine. I know, and you've told me that every time we've had a status conference, and I'm telling you, we are still within the statutory timeframes, and everybody's following the statutory requirements. We should receive a report from your treatment facility before the next status conference, because that'll be a 90-day marker, and I believe they're required to provide us with that. So we should have more answers and more direction at the April status conference. We've just been setting this so we don't lose track of the case.
Okay, I guess I
There's
just have one question then. Do I have to be in a facility for an IST, or am I allowed to be a stay-at-home mom with this being in an order?
At this point, you are ordered to be there, and you should cooperate with the treatment that they're giving. Okay.
Okay, what about my children? My 18-month-old I've seen 3 times because of this. Over retail fraud. I mean, you guys are acting like I committed murder and I'm in question for murder or hate crime. I just seen someone get hate crime or felony status, hate crime, and they're getting a year per misdemeanor and I've been doing this for 8. That makes no sense to me.
All right, well, Ms. Sprague, you are facing felony charges, and as I've said, I don't have any answers for you today until we get a report from the treatment facility, which should be due before the next status conference. So I've got no answers for you today. We're just trying to not lose track of the case. Your next hearing will be the April 11th at 8:30. I do want to let you know it won't be me. I've just been filling in when Judge Barton retired. Judge Mike Ekdahl is taking the bench next Monday. So he'll be the judge on your case in the district court from that point forward, okay?
Okay, is there any way you can order for me to have meetings with my lawyer? And so I've never met with my lawyer since I was in your jail.
Well, he can't really go into the treatment center and meet with you there.
Well, I have a visitor room. He absolutely can.
Well, you can arrange a Zoom meeting, but he can't do anything until we get the report from them as well, so.
Okay, because I thought in while I was innocent until proven guilty, and it was supposed to be a clean record expungement. This
Well, you
makes no
still
sense.
are.
I understand.
still
you're
are.
on here.
You still are presumed innocent, Ms. Spra. All right, and we'll see you April 11th. We'll get the report from the treatment center. Okay? Just
Thank you for your
continue to
service.
cooperate with the treatment.
Appreciate you.
All right, and then we have People v. Carl Smith.
Mr. Smith is present.
Looks like this is file 21-0787 ST up for a pretrial on a suspended license charge and a contempt hearing for failing to appear for that a couple of years ago. So where are we at on that?
Your Honor, in regards to the underlying charge, I do have a signed device of rights and a signed plea agreement. And in regards to the contempt, Mr. Smith is going to admit that he did not appear and explain why.
All right, if you can approach. All right, and Mr. Smith, the plea agreement is for DWLS first, dismiss the second offense. Driving on a suspended license, first offense is a misdemeanor punishable by a maximum of 93 days in jail and/or a $500 fine and possible vehicle immobilization. Do you understand the maximum penalty?
Yes.
Did you read and understand the rights listed on the advice of rights form?
Yes.
All right, and do you have any question about those rights? Do you understand that when you plead guilty, you give up those rights?
Yes.
And is that what you wish to do today?
Yes.
Other than the plea agreement for dismissal of the second offense, has anybody promised you anything?
No.
Has anybody threatened you?
No.
And you know, for the contempt for failing to appear, that's a maximum 93 days and or $700 fine. Do you understand that?
Yes.
All right, Mr. Has anybody threatened you to make you plead? Mr. Gilbert, are you aware of any other promises, threats, or abuse?
I am not, Your Honor.
Ms. Miller?
No, Your Honor.
All right, Mr. Smith, how do you wish to plead then to a charge of driving on a suspended license
Good.
and to contempt for failing to appear?
Good.
So back in October of 2021, were you operating a motor vehicle on a public highway in Sheboygan County?
Yes.
At the time, was your driver's license suspended or revoked?
Yes, sir.
Why was it suspended or revoked?
I've never had one.
So you knew that it was suspended or revoked.
Yeah.
And did you fail to appear for court back in 2021 then?
That's the complicated part. I left and went to Mississippi to take care of my mom. She was really sick. Mr. Varga was representing me at the time and we did a video thing. So I didn't appear. I was on the video, but at the time I was working in Sawmill down there. It glitched out. So then I ended up going in and I did some incarceration time in Tennessee. Some rehab time as well. So when all this took place, I sent a note. I was trying to make sure it was still taken care of and done. So when I came home, I didn't have this. I got back here. I called district court and asked, still, this is, was it taken care of as I presumed? They said yes as well. Well, then I ended up coming in on it because it showed somewhere. So, but I wasn't able to finish the process. So,
Okay.
I accept that, but.
Okay, and you were never at a hearing where the case was brought to a point of conclusion?
We were actually at the very last part. He was supposed to be done with just receiving a fine for the ticket and been done with it. And like I said, when it glitched out, we weren't, I guess they would have, Varga must not have finished it without me or whatever have you, I guess.
Okay. All right, Mr. Gilbert, you satisfied with factual basis?
I am, Your Honor.
Ms. Miller?
I am as well.
All right, Mr. Smith, I find that your plea is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to believe you're guilty of the charged offense or the offense you're pleading to, and also to find you in contempt for failing to appear. I guess, Mr. Smith, are you on paper anywhere now?
No, sir.
Okay, you're back in Sheboygan?
Yes, I've been, like I said, I worked really hard to.
Are you working?
Yes, I am, sir. I work for working doors, working out there, really Ross.
When's your last, other than on this warrant, when's your last arrest on?
I haven't had anything since I finished my stuff down there. I did almost 8 or 9 months down there, and then I did another 4 months in a rehab facility. I definitely done the best I can do.
All right, Ms. Miller, any objection to immediate sentencing?
No, Your Honor, that's fine.
Mr. Gilbert, go ahead.
Your Honor, I believe my client is pretty much
Yeah. that's-
allocated for himself very well, and I believe there was some extenuating circumstances in this situation, and I would ask the court to consider fines and costs.
Thank you. Mr. Smith, is there anything else you want to comment?
If there's any other different, I'm not really prepared yet. I mean, I had my place and stuff since I've gotten back.
I'm not giving you.
Oh, okay. Thank you.
All right, Ms. Miller, any recommendations for the people?
Your Honor, I would support a sentence of fines and costs for the driving while license suspended. It does seem like there was some incarceration between the time that he was last here and now that contributed to his unavailability for court. However, this is a 2021 case, so I would ask that the court maybe do a day with the work crew for the contempt.
All right, thanks. Well, Mr. Smith, you've, I mean, you and I are familiar with each other over the years, and, you know, hopefully what you're saying, if you haven't been arrested in a while on anything new, hopefully you've turned over a new leaf after the treatment, and time will tell. Time will tell, but I think I'm gonna clean this case up for you and just give you some fines today for it. So it's $100 penal fine, $200 in court costs, $50 state fee, $75 crime victims assessment for $425 total. And on the contempt failing to appear would be $100 fine. So that's a total of $525.
Yes.
And if you can't pay that in full today, you can fill out some paperwork as for a payment plan at the counter. We are going to enter a judgment on the case for contempt and for the DWLS. So you may appeal that if you wish by filing an application to the circuit court within 21 days. And if you wanted a lawyer, you'd have to ask us within 14. Any questions for me, Mr. Smith?
That's fine. Thank you very much.
Okay, good luck to you.
No, thank you. Thank you, sir.
All right, so Mr. Gilbert, are you here, Mr. Ladd?
Yes, Mr. Ladd has done it. I talked with him yesterday, and we believe we have a resolution. It's going to result in a civil infraction, but I had not seen him yet this morning.
Okay. All right, but that's a civil infraction resolution, Ms. Miller?
That is, I did receive the valid proof of insurance, so I think he just needs to take care of it with the window.
Well, and that can usually be done on paper. So what we'll do is you can take care of that when he's here today at the traffic window. If there was some miscommunication about his appearance, I'll just set it for our next pretrial date is April 11th at 8:30.
Thank you very much.
And then we've got Conor Vandy, 4-038 SM. Right, and we're here for final pretrial.
Yes, Your Honor, and going through I have been in receipt of a plea. I've gone through this with my client, and we'd asked to be put on the trial docket.
Okay, and on Monday, Judge Ekdahl is assuming office. So I don't want to schedule things for him. So I think what we'll do is I'll continue this to our next pretrial docket day, and then he can get a trial date. It's in his calendar, so that'll be final pretrial April 11th at 8:38.
Excellent, thank you.
Yes.
And there's People v. Courtney Wenger, file 24-080.
Yes, Your Honor, and I did meet with Ms. Wagner this morning, and we've got our communications back in sync, I think. And I have presented her with a possible plea from the prosecutor. I do want to speak with the prosecutor a bit more, so we'd ask that this be set for a final pretrial.
Okay, we can schedule this then for a final pretrial on April 11th at 8:30 a.m.
Thank you.
I'll see you.
Thank you, Your Honor.
And anything else you want to cover?
Not on my 8:30 docket, Your Honor. I do have a 9 o'clock with for a show cause, but I spoke with her yesterday, but I'd like to talk to her a little bit.
Okay. All right, we'll go off the record until we're ready to be ready. All right, so we are back on the record, and as a reminder, we are today providing public access both in the courtroom and also online. We have a show cause. People being Amber Keeler, file 24-057 FY. It looks like this is Ms. Keeler. It's alleged that you are in contempt of court by violating the condition of your bond. The bond condition was that you may not have any animals in your possession, so it's alleged that you did violate that provision. You have the right to have a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at any such hearing. If you are found to be in contempt, you could be jailed up to 93 days and or fined up to $7,500. And Mr. Gilbert, with Ms. Keeler being advised of her rights and the penalties, do you know how she wishes to proceed?
We're going to request a hearing, Your Honor. I believe the dog was transferred to another individual and he was present at the time.
Okay, well, I think maybe what we'll do is we'll schedule it for a well, I suppose we could probably just schedule it for a hearing at the same time as the sentencing on April 5th. Any objection to that?
I don't know.
Okay, so we'll schedule it for a contempt hearing on April 5th at 11:30 a.m., the time that Ms. Keeler is already scheduled for sentencing.
Thank you very much.
Your Honor, I guess I'm concerned about the possession of the dog in the meantime, if she's ordered to not have any dogs in her possession, and CPS, it's alleged that CPS saw it there and she indicated that it's her dog. I don't know if they can provide proof to the animal control that it's somewhere else, or if animal control can hold it until the sentencing just to determine, but I am concerned about the Ms. Keeler continuing to have possession of that dog in the meantime.
Your Honor, it's my understanding that the dog has been taken by the new owner. They're just waiting on Monday for shots to be updated so that it can be changed at the county. Registration can actually be changed.
The dog is not in your client's possession today.
That's my understanding.
Can we add a condition that there's no dogs in her residence at all? If people come over and bring dog, I just to make sure that there's not dogs being put in any kind of harm.
Well, I mean, the bond condition is that she not have dogs in her possession. You know, bond conditions have to be reasonably related to the underlying case, and if it's that she didn't care for an animal, I'm not sure if, you know, if I go over to her house to visit and bring my dog and my dog's in my care, I'm not sure how I'm going to deny that request.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Worko, you want us to do Mr. Weatherwax because he's in the jail arraignment room?
Court's discretion, Your Honor.
All right, up next, we've got a show cause hearing. People be Chase Weatherwax, file 24-032 FY. And we have a contempt hearing scheduled April 5th at 10:30. This is an arraignment on a new allegation of contempt that Mr. Weatherwax is allegedly in contempt of court for violating conditions of the bond order of the court by continuing to have phone contact with the victim. Mr. Weatherwax, of course, you have the right to have a hearing on that allegation as well, where it would need to be proven beyond a reasonable doubt in the assistance of your attorney at that hearing. If you are found to be in contempt, you could be jailed up to 93 days and or fined up to $7,500. And Mr. Wergo with Mr. Weatherwax being advised of the penalties and his rights. Do you know how he wishes to proceed?
Your Honor, I do believe that the alleged conduct and contact in this matter also was the basis of a contempt for this exact same contact and conduct in a personal protection order hearing in the circuit court. I believe that Mr. Weatherwax admitted to that contact. We would ask that, and he was sentenced for that contaminacious conduct and contact. We would ask that the court essentially hold that this matter has been resolved for due to the sentencing and the handling of that in the circuit court.
Okay, what's the contempt on April 5th for? Did you know what that hearing is for?
Your Honor, I believe that would have been from the original contact at the apartment. There was
Oh, okay.
originally a not guilty plea and then that was set out. But Mr. Weatherwax has since admitted to that conduct before the same judge, Your Honor, sitting in a different court.
Right, okay, well, I mean, one is the PPO matter and the other is a criminal matter. I think the district court may continue to proceed on it. So I think what I'll do, we're already scheduled on the 5th for the contempt for the original in-person contact. I'll just schedule this telephone contact for contempt hearing at the same date and time, April 5th at 10:30. And that'll be before Judge Ekdahl, and he can decide whether he wishes to proceed in the district court on it or not.
Your Honor, then my request would be that bond be continued in that, because I do believe that Mr. Weatherwax's sentencing on the contempt matter in the circuit court he would be released on that prior. He does have a very lucrative job up on the Sioux Locks that is good for everybody if he can get to that job.
Oh, so he's sitting on a no bond in this court based on the contact. Is that right, Ms. Miller?
I believe so, that I believe that the bond was revoked for the violations of contact.
Okay. Well, I guess, can counsel approach me? All right, Mr. Weatherwax, I needed to speak with the attorneys because we wanted to coordinate what had happened with the PPO matter up in the circuit court. Of course, those are legally separate matters, even though they're based on the same factual predicates. And the prosecuting attorney in this case does want to continue to pursue bond violation in the pending felony. So I'm gonna schedule this then for a contempt hearing on the second contempt at the same time as the first contempt, so April 5th at 10:30 a.m. When I sentenced you on the PPO, I was dealing only with PPO violations. This being a pending felony charge with a violation of bond with no contact, it's a fairly standard procedure for bond to be revoked in that matter, and it continues to be revoked. So despite your outdate on the PPO matter, your bond in the district court pending felony will continue to be revoked until further order of the court, and the next hearing is the April 5th contempt hearing. All right, see you then. Virgo, you ready on Mr. Carney?
Yes, sir.
We're not going to address the new matter. We'll set that for arraignment tomorrow. Then.
Yes, Your Honor, that would be appreciated.
We'll call that one. All right, so we are here today on file 23-724 SD. In that case, we are scheduled for a sentencing tomorrow, but we did have it noticed up today for a bond violation show cause. And Mr. Carney, it's alleged that you are in contempt of court for violating a condition of your bond to not use or possess controlled substances by testing positive for amphetamines in a test collected on February 14th of 2024. If you are found to be in violation of your bond, the court can sentence you to up to 93 days and or $7,500 fine and or revoke your pretrial release. You have the right to a hearing where it would need to be proven beyond a reasonable doubt the right to the assistance of your lawyer. And Mr. Carney being advised of his rights and penalties, do you know how you wish to proceed?
Not guilty, we'd like a hearing, Your Honor.
All right, so I think what we'll do is, since we are up for sentencing tomorrow morning at 11 a.m., I'll schedule this for a hearing tomorrow morning at 11 a.m. It's possible that the prosecutor's office may be able to secure a witness to have that hearing. And then if they're not able to, we'll address it tomorrow. We may have to adjourn stuff and see what we'll do. And then tomorrow morning, as Mr. Wergo advised you, I think we'll also add to the docket to arraign you on a new charge that was just filed today from last summer. But we're going to recall that warrant so you don't get picked up on it.
Okay.
And Your Honor, the matter's tomorrow at 11 a.m. Is that correct?
Yes. Yeah. We'll do the arraignment.
And then, Your Honor, is that bond continued in the underlying matter?
Yes.
Thank you.
All right. See you tomorrow morning, Mr.
All right, thank you.
And read Mr. Keeler then.
Yes, Your Honor.
And this is a bond violation show cause. Whether it's alleged that you're in contempt of court by violating a condition of your bond to not have any animals in your possession. It's alleged that you did have animals in your possession. You have the right to have a hearing on that allegation where it would need to be proven beyond a reasonable doubt and the right to the assistance of your lawyer. If you are found to be in contempt, you could be jailed up to 93 days and or fined up to $7,500 or both, or the court could revoke, we can just revoke your pretrial release. And you have the right to have your attorney at that hearing and to present evidence in your own defense and cross-examining evidence against you. And Mr. Wergo, with Mr. Keeler being advised of his rights and the maximum penalties, do you know how he wishes to proceed?
We plead not guilty and request a hearing, Your Honor.
All right, well, we're scheduled for preliminary examination on April 5th at 10:30 a.m. We'll schedule this for a contempt hearing at the same date and time. In the co-defendant's matter, the prosecutor was wanting some assurances through counsel as an officer of the court that that the client has confirmed to you that the animals are no longer at the home.
Yes, Your Honor, and we did speak about that yesterday, and no dogs at the home. We had a very detailed discussion about that.
All right, anything further, Ms. Miller?
No, Your Honor, thank you.
All right, Mr. Keeler, we'll see you. Thank you. Wergo, do you have any other matters you're going to do?
A litany, Your Honor, but I believe they are not until 11 o'clock.
Mr. Varga, do you ran an attorney?
Yeah, I don't know, Your Honor. I haven't even stopped at the PD's office yet.
There's somebody in the waiting on Zoom. It says moved by nature.
And Your Honor, for the record, Nicole Williams is being resolved as a civil infraction, so that can be taken off the docket.
So 24-136 ST Nicole Williams, that becomes the civil infraction.
Yes.
Good morning, sir. Can you tell me your name, please?
Andrew James Senadenos. Good.
All right, and Mr. Senadenos, have you spoken with the arraignment attorney this morning yet, or no?
I did just briefly.
Okay, all right, well, let me place you back in a waiting room until he's down in the courtroom. He's still meeting with some folks, okay?
Thank you very much.
All right, so we'll go off the record until Mr. Vargas. Ready. All right, we're back on the record in the 89th District Court for the County of Sheboygan and providing public access both in the courtroom and also online. And Mr. Varga, you ready with arraignments this morning?
Yes, I am, Your Honor. Thank you.
Who do you want to call first?
Again. We can take Mr. Senadenos if you like.
Okay, it's in the Zoom meeting room. All right, Mr. Senadenos, good morning to you, sir. We are here for an arraignment. Mr. Vargas here on your behalf, and this is an arraignment on the underlying charge and also a show cause for failing to appear at the initial arraignment. Mr. Senadenos having appeared now, we'll go ahead and dismiss that contempt for failing to appear. And Mr. Varga, as to the underlying matter.
Yes, Your Honor. Thank you. Prior to this case being called by the court, I had an opportunity to talk to Mr. Senadenos and discuss the facts and circumstances surrounding his case. I indicated to him what the charges are as well as potential penalties. He indicated back to me that he understood the charges and penalties, and given that understanding, the way the form reading into the record, we then moved to his advice rights form. I reviewed those rights with him, enumerated those rights for him, indicating he understood those rights, had no questions, and he did give me permission to sign the advice rights form on his behalf. I did so, and it's already been forwarded to the court. We are ready to proceed to arraignment. In this case, Mr. Senadenos is going to be hiring his own attorney, Your Honor, and he's asking the court to enter a plea of not guilty on his behalf and set this case along its usual pretrial schedule.
All right, thank you. So, Mr. Senadenos, you having waived the formal reading, I won't read it formally. I'll just advise you you're facing a charge of driving on a suspended license, second offense. It's a misdemeanor punishable by up to a year in jail and or $1,000 fine. And you have the right to the assistance of an attorney and a right to a trial. And Mr. Varga indicates that you are hiring your own attorney. So we will schedule this for a pretrial conference on April 11th at 10 a.m. And Mr. Varga, as to bond?
Yes, Your Honor, the appearance bond, Mr. Senadenos is on right now. He's a resident of Mason, Michigan. He's lived there for quite some time. He's a retarded individual. So he's not employed at this point in time. He indicated to me he has a criminal history, but dates from his younger days, including possessions of marijuana, as well as some bar fights he was involved in during his younger years. I think a personal bond is appropriate here. Your Honor.
Ms. Miller?
Thank you, Your Honor. Mr. Senadenos is 61 years old with an address in Mason, Michigan. I do see a pretty significant criminal history, although I would agree that most of it is quite old. Looks like 1, 2, 3. All the charges except one would be in between 1980 and 2000. There's a more recent conviction in 2012, but that is the most recent one. He has appeared today. I do see on his record that he is a want from Sault Ste. Marie for failing to appear, as well as a bench warrant for failing to appear on a show cause from 2022. But the nature of this case, he's appeared here today. So I think going forward, I wouldn't have an objection to appear bond.
All right, so Mr. Senadenos, we're gonna set your bond as a $500 personal bond. So you don't have to post that today, but that would be an amount you'd forfeit if you fail to appear. It'll be standard conditions that you do have to appear for court. You can't leave the state without permission. You can't break the law. And you have to tell us if you change your address or phone number. So I've given you your court date, the April 11th at 10 a.m. When you hire your attorney, if you and your attorney wish, you can contact the court. It's an in-person hearing, but you and your attorney can fill out a form to request to appear by Zoom. I don't want to approve that today. I want to make sure you have your lawyer and whatnot. But you can fill that out, and it'll be reviewed, and you may be able to appear by video, okay?
Yes, sir. Yes, Your Honor.
Any other questions for?
I had one quick question. I know you guys are very busy. If I misunderstood, there was an offer maybe on the table. Was that a civil infraction? No ops in possession? Because I probably could plead to that right now if that's the case. I just can't plead to a traffic stop because then it's going to make it tough for me to get a license down the road.
Sure. Well, I'm not privy to those conversations, but no ops in possession is still a misdemeanor offense. It's not a civil infraction.
And that was not the
Okay.
offer that was.
And the prosecutor says that's not the offer anyway.
Okay, I'm sorry to confuse anything. Please continue, Your Honor.
Okay. All right. We'll see you on the 11th, sir.
Thank you, Your Honor.
You have a good day.
You too.
Your Honor, is Miss Midet, in the waiting room?
Yep.
I would deal with her.
All right, Ms. Midet, can you hear me? Hello, Ms. Midet, can you hear us? No, we're not really hearing you. Hello?
Hello?
Yep, now I hear you. All right. All right, so we're here in People v. Joyce Midet, file 24-111ST. Mr. Varga?
Yes, Your Honor. Again, good morning to the record. Ronald Varga, on behalf of Joyce Midet, who I talked to earlier today. During that conversation, I reviewed with her the charges that were filed in this matter, as well as potential to those charges. She understood both the charges and the potential penalties, and given that understanding, she had waited for reading the information in the record. I then moved to her advice of rights form, reviewed that form with her, explained those rights to her. She understood those rights and had no questions regarding those rights. And to that end, she allowed me to sign her advice of rights form on her behalf. The advice of rights form has already been filed with the court. We are prepared to proceed to arraignment. Ms. Midet's going to request that the court enter not guilty plea on her behalf. She is seeking the assistance of counsel. She is financially eligible. ask the court to set this on to the pretrial procedure.
Do you know to whom it'll be assigned?
It'll be assigned to Mr. Warren.
All right, so Ms. Midet, with Mr. Varga indicating you're reading, I won't formally read the charges, but I'll just advise you, you're facing a charge of operating on a suspended license. It's a misdemeanor punishable by a maximum of 93 days in jail and or a $500 fine and vehicle immobilization. We will refer it to the Office of Assigned Counsel for appointment of Mr. Wargo. And of course, you have the right to the assistance of an attorney and to right to a trial. And we'll schedule this for a pretrial conference on April 11th at 11 a.m. As to bond, Mr. Varga.
Yes, Your Honor. Ms. Midet is a resident of Sheboygan County. She's been a resident for some period of time. She's not employed. She's currently disabled. You can ask the court for a personal violence matter. I'm not sure the existence of criminal history. I would hazard a guess to say it's not extensive, but I don't have confirmation of that.
All right, Ms. Miller.
Thank you, Your Honor. Ms. Midet is 50 years old with an address in Atlanta. I don't see criminal history for her. I don't have an objection to a PR bond being issued for her. I just ask that she not drive without valid license or insurance. Thank you.
All right, Ms. Midet, we're going to schedule this. I gave you the pretrial date. I set it as a personal bond of $500. You don't have to post that, but that's an amount you forfeit if you don't appear. It'll be standard conditions of appearing for court, not breaking the law, not leaving the state without permission, letting us know if you change your address or telephone number, and special condition on request of the prosecutor that you not operate a motor vehicle without a valid license and insurance. All right,
Okay.
any questions for me, Ms. Midet?
No, sir.
Repeat that date, please.
Yeah, the date is April 11th at 11 a.m. All right, you have a good day, Ms. Midet.
You as well.
Case of People versus Melissa France.
All right, this is People v. Melissa France, file 24-097 SM. We are here for arraignment, Mr. Barker.
Yes, Your Honor. The arraignment is going to move to a plea taking as well. Prior to coming to court, Ms. France, charges in the violence matter. And she understood the charges with way the formal reading. But I also reviewed with her at that time the plea offer that's been tendered by the prosecuting attorney. And Ms. France would like to avail herself of that plea offer, which involves a reduction of the charge to an attempt at retail fraud with recommendation of with an agreement of no jail, no probation, but she must complete the economic crime program within 30 days. There's restitution set at $127.35. I will present the court with the rest of arguments to that effect. We also reviewed the advice rights form, Your Honor. She signed that advice rights form on behalf.
Right. So, Ms. France, the offense of attempted retail fraud in the third degree would be a misdemeanor punishable by a maximum of 46.5 days in jail and or a $500 fine or 3 times the value of the property involved, whichever is greater. Do you understand that maximum? Yes. Okay, did you read and understand the rights listed on the advice of rights form?
Yes.
Do you have any question about those rights? No. Do you understand if you enter a plea, you're giving up all those rights? Yes. And is that what you're choosing to do today? Yes. The plea agreement says in exchange for your plea to the attempt, the prosecutor will dismiss the principal charge. Restitution is agreed upon of $127.35. And there's a sentence agreement of no jail or probation, but that you complete an economic crime program within 30 days. And there are some online options for the class as well. Do you understand the terms of that plea agreement?
Yes.
Has anybody promised you anything other than that?
No.
Has anybody threatened you in any way to make it? No. Is it your own free choice to do so?
Yes.
Mr. Varga, are you aware of any other promises, threats, or inducements?
No, not Your Honor.
Ms. Miller?
No, I'm not.
All right, Ms. France, knowing all these things, how do you wish to plead to the charge of attempted retail fraud in the third degree?
Guilty.
Mr. Varga, would you assist with factual
I
details?
will, Your Honor. Ms. France, on or about January 26th, were you shopping in the local Walmart?
Yes.
And when I say local Walmart, that's the Walmart located in Sheboygan, Michigan. Is that correct?
Correct.
And you had put some items in your cart, and when you went through the self scanning aisle, did you fail to scan several of those items? 3, and you intended to leave the store without paying, was that a thing, right?
Well, it wasn't intention, but they think it's scanned.
You didn't get scanned. And that all occurred before you got it.
Yes.
I think that's sufficient, Your Honor.
Ms. Miller?
I mean, I would agree that the items didn't get scanned. I don't know if we need to do an amount for the retail.
Oh,
property.
was it some amount less than $200, Ms. France?
Yes.
All right, could counsel approach, please? All right, we're back on the record. And Ms. France, I'm going to find that your plea is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to accept that plea. So I will do so. And Ms. Miller, any objection to an immediate sentencing?
No, Your Honor, that's fine.
Mr. Barker?
Your Honor, no, I would have no
Go ahead
objection.
with any allocution.
Miss France is currently 56 years of age. She's self-employed as a network marketer. She owns her own homes in a 28-year residence in Boyden County. She has no prior criminal history. This is the only first blush on her record, so to speak. So I'd ask the court to limit sanctions to fines, costs, and restitution.
All right, thank you. Ms. France, you don't have to say anything today, but is there anything you want to tell me? Ms. Miller, any recommendations from the committee?
Yes, Your Honor, Ms. France is 56 years old with an address in Sheboygan. She doesn't have any prior criminal history. On the underlying facts of the offense there was a number of dates where Ms. France took some items without paying for them, December 24th, January 12th, and January 26th. The 26th was when she was stopped by Walmart staff, but there is an outstanding restitution amount of $127.35 for the 2 prior times when the items weren't retrieved by Walmart, so I'd ask that that be ordered. But I'd also ask the court to follow the sentence agreement for no jail, no probation, and require Ms. France to complete the economic crime program within 30 days. Thank you.
Great, thank you. Well, Ms. France, you know, there's oftentimes a whole lot of factors or reasons why somebody might make a decision that's not fantastic at those self-scan things. Doesn't make you a bad person. And looking at criminal history, you're not not a bad person. And so I don't see anything on your record that gives me any cause for concern. So I'm going to go ahead and follow this plea agreement. I'm not going to place you on probation, but I am going to order you to complete that economic crime class within 30 days. You have to provide proof to the court that you've done so. Otherwise, you'd have a show cause for contempt. Now, assess fines and costs only. There's a $175 penal fine, $200 in court costs, $50 fee to the state, $75 crime victims assessment, and $127.35 in restitution. That's a total of $625.35. If you can't pay that in full today, you can fill out some paperwork at the court window for how much you're able to pay per month in the consent. Because we are issuing a judgment, you can appeal that if you wish by filing an application to the circuit court. You have to do so within 21 days. If you wanted us to be a lawyer, you have to ask within 14. Do you have any questions for me? Okay, good luck.
Thank you very much, Ron. Last case on this morning's docket, Your Honor, is People versus Jacob Hogan.
Great. Jacob Hogan filed 24-0141 S2. So this is up for a
Arraignment, Your Honor. I believe there's a show cause.
Show cause for failing to appear at
March 4th.
All right, and Mr. Hogan being here today, we'll go ahead and dismiss that contempt as to the arraignment, Mr. Barber.
Yes, Your Honor, the arraignment is going to proceed to a plea taking, but prior to coming forward, I reviewed the charges against Mr. Hogan. He understood the charges as post-possession penalties. I reviewed with him a plea offer that was tendered by the prosecution. He indicated a willingness to avail himself of that plea offer. And finally, we did discuss his advice rights form. We reviewed that form. He signed that form on his own behalf, which has already been filed with the court. We'd like to proceed to a plea taking. The offer is involved is to a plea to a DDoS first offense with a sentence agreement of immediate sentencing, fines and costs only.
All right, and Mr. Hogan, you understand operating on a suspended license is a misdemeanor punishable by up to 93 days and or a $500 fine, vehicle immobilization. Do you understand the penalty, the maximum penalty?
Yes, sir.
Did you read and understand the rights listed on the advice of rights form that you signed?
Yes, sir.
Do you have any question about those rights?
No, sir.
Do you understand if you plead guilty, you give up those rights?
Yes, sir.
Is that what you wish to do?
Yes, sir.
The plea agreement is in exchange for your plea, immediate sentencing to fines and costs only. Do you understand that agreement?
Yes, sir.
Has anybody promised you anything else?
No, sir.
Has anybody threatened you?
No, sir.
Is it your own free choice to have that plea?
Yes, sir.
Mr. Varga, you aware of any other promises, threats, or inducements?
I'm not, Your Honor.
Ms. Miller?
No, Your Honor.
All right, well, Mr. Hogan, knowing all these things, how do you wish to plead to the charge of operating a suspended license?
Guilty.
So on February 27th of this year, were you operating a vehicle on I-75, a public highway in Sheboygan County?
Yes, sir.
And was your driver's license suspended or revoked?
Yes, sir.
Why was it suspended?
From previous charges when I was younger, I made bad decisions when I was younger, and I still haven't worked on getting it back yet.
Okay.
It's gonna cost money, and time. And I've been really focused on work right now.
Mr. Varga, you satisfied with the facts of business?
I am, Your Honor.
Ms. Miller?
I am as well.
Mr. Hogan, I find that your plea is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to believe that you are guilty of that offense, so I'll accept your plea. And we can proceed to immediate sentencing. Mr. Varga, go ahead.
That's correct. Thank you, Your Honor. Mr. Hogan is currently 23 years of age. He is a long-term resident of Muskegon, or the Muskegon County area. He currently resides in Muskegon. He is employed in the construction trades. He works for Slater Contracting. And then he also works in the weekend for all construction. He is employed, and he's got a job site in the UP, which he hopes to get to on conclusion of these matters. Unfortunately, he does have a criminal history involving several prior DWSs, which include him trying to easily get a license restored to him, but he is going to work on that. I ask the bargain and assess fines and costs only.
Thank you, Mr. Hogan. I'm sorry, Ms. Miller.
Thank you, Your Honor. Mr. Hogan is 22 years old with an address in Muskegon. I do see a criminal history that involves prior operating while intoxicated offenses. It looks like there's also a pending operating while intoxicated case in the 16th Circuit Court. However, I think that due to the nature of this, it could just be sentenced to fines and costs at this point, and those other cases can be resolved in their own way.
All right, Mr. Hogan, is there anything you want to tell me or no?
No, sir.
Have you complied with the fingerprint order yet?
I'm gonna go do that right after this.
All right, well, I'm going to sentence you as agreed upon to immediate sentencing, fines and costs, $100 penal fine, $200 court costs, $50 fee to the state, $75 crime victims assessment for a total of $425. Can you pay that today?
No, I'd have to do a.
You can fill out a request at the court window for a payment plan. Be sure to comply with the fingerprint order before you leave today. And then be sure to follow up on that payment plan, set one up that you know you can do.
Yes, sir.
Because otherwise then we gotta get you back here on contempt and stuff like that.
Yeah, yes, sir.
All right, we are issuing a judgment, so if you want to appeal, you can file an application to the circuit court within 21 days. If you want a lawyer, you have to tell us within 14. Do you have any questions for me, sir?
No, sir. Thank you much. Thank you.
Your Honor, that concludes our morning document.
All right. Sir Nicholas Oden in the courtroom. Mr. Oden, you want to come up to the podium here? Mr. Oden, you're here for a pre-trial. Are you representing yourself for this matter?
Yes, sir.
Okay, and this is file 24-102 ST. And as I said, it's up for a pre-trial conference. Have you had a chance to speak with the prosecutor? Do you know, have you resolved the matter with the prosecutor's office or no?
Yes, sir. Yesterday.
Oh, do you have a plea agreement then?
Yes, sir.
Okay, can you hand that to a bailiff?
If Mr. Odd needs to fill it out, so you need to indicate, accept if you'd like to accept it and then sign it.
All right, Mr. Oden, now you do have the right to, well, did you read and understand the rights listed on the advice of rights form?
Yes, sir.
Did you fill one of those out today?
Not today, no. I believe when I was here for the arraignment, I did, possibly, for the fingerprinting.
Okay. All right, so you understand you've got the, you have the right to have a trial by judge or jury, and at that trial to be presumed innocent unless until the prosecutor proved your guilt beyond reasonable doubt. You have the right to confront and cross-examine the witnesses against you, to present witnesses in your own defense, to testify in your own defense, or to remain silent and not have your silence used against you. Do you understand those rights?
Yes, sir.
Do you understand if you plead guilty to an offense, you give up those rights?
Yes, sir.
And is that what you're choosing to do today?
Yes, sir.
Okay, now the plea agreement is in exchange for charge of no license on person under section 311 of the public health or of the motor vehicle code. Prosecutor will dismiss the DWS charge, and there's a sentence agreement for immediate sentencing to fines and costs only. The no license on person is a misdemeanor punishable by 90 days and or $100 fine. Do you understand the maximum penalty?
Yes, sir.
Do you understand that plea agreement?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes, sir.
Knowing all this, how do you wish to plead to no license on your person?
Guilty.
So on February 9th of this year, were you operating a motor vehicle on I-75, a public highway in Sheboygan County?
Yes, sir.
Did you have some contact with Michigan State Police Trooper?
Yes, I did.
And they asked for typical things, license, proof, insurance, registration, all that.
Yes, sir.
And did you have in your possession a valid Michigan operator's license?
I did not. I was unaware. It had been suspended 2 days prior, and I didn't receive notification in the mail until actually a day after I had returned home to Clio. And I took care of the ticket while the officer was at my windows for a ticket for no insurance that I had received back in November that I was unable to pay at the time and then forgot about.
Okay. Thank you. All right, Ms. Miller, you satisfied with that factual basis?
I am.
All right, Mr. Oden, I find that you please knowingly, voluntarily, and understanding made that there is a sufficient basis in fact and law to accept your plea, and I'll do so. Is there anything else you want to tell me about the situation, sir, or no?
No, sir. Thank you.
Ms. Miller, any recommendations from you?
Your Honor, I would just indicate for the court that Mr. Oden has already restored his license, so I think that the fines and costs are appropriate and ask the court to follow the agreement.
All right, Mr. Oden, I'll go ahead and do that. It's a $15 fine, $50 in court costs, $50 fee to the state, $75 crime victims fund, for a total of $190. Are you able to pay that today at the window?
Yes, sir.
Okay. And we'll enter a judgment, so you can appeal from that judgment if you wish by filing an application to the circuit court within 21 days. If you wanted a lawyer, you'd have to make that request within 14. Do you have any questions for me, sir?
Not this time. Thank you.
Stick around before I have some paperwork for you.
Step
All
right.
right, just stick around on the hallway. Yeah, you're all set. Thank you, sir.
Thank you.
Great, Mr. Kukeski, do you have anything that's ready or no?
I do, Your Honor. I'm ready both on Bradford and Bullard.
Andrew Bullard. This is file 24-0105 SM. Just so you're aware, because we don't normally do it down here, we are providing public access today, both in the courtroom and also online. We are here for a pretrial domestic violence second offense charge. And it looks like a show cause. All right, so Mr. Bullard, it's alleged that you are in contempt of court for violating the condition of your bond by testing positive for alcohol in a test collected on February 23rd. You have the right to have a hearing on that allegation where it would need to be proven beyond reasonable doubt, and the right to the assistance of your lawyer in any such hearing. If you are found to be in contempt or admit to it, I could jail you for up to 93 days, fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. And Mr. Kukeski, with Mr. Bullard being advised of his rights and the penalties, do you know how he wishes to proceed on that contempt?
On the contempt, Your Honor, I think we'll be requesting a hearing so we can look into the matter a little bit further.
Okay, so we'll enter a not guilty plea to the contempt and schedule it for a hearing. Where are we at on the underlying case then?
Well, Your Honor, I have received an offer from the prosecutor to just plead to count one with the dismissal of second offense notice. We're still contemplating that offer, but we request a final pretrial from the court.
All right, well, what I'll do then is I'll schedule it for a final pretrial on April 11th at 10 a.m. We'll schedule it for a contempt hearing on the alleged violation at the same date and time. Mr. Bullard, I'll just caution you, as I'm sure Mr. Kukeski already has, that I don't want you to tell me anything about this alleged violation, but that's concerning to the court. And if there's more of that comes our way, the prosecutor may very well ask for a warrant for your arrest, and it may very well be signed. It may be sitting in jail while you
Yes, sir.
So if you were drinking, knock it off. All right. Any further, Mr. Kukeski, on this file?
Nothing further, Your Honor. Thank you.
Okay, you're all set, sir.
Thank you.
All right, thank you. And people be Bradford, file 24-112 SM for a pretrial. Status in this matter.
Again, Your Honor, I did receive an offer from the prosecutor for an attempted count one. At this time, my client is still contemplating that, but we're going to request a final pretrial. There is some information that I want to provide back to the prosecutor. As well.
Okay, we'll schedule it for a final pretrial then on April 11th at 10 a.m.
Your Honor. No, Your Honor, sorry.
All right, you're all set. Stick around the court window. I'll have some information.
Very good. Thank you, Your Honor. Okay.
So, you have anything else this morning? Oh, you do.
I do, but they're a little bit later, Your Honor. I did meet with my probable cause conference client, Mr. Gamaz. We did sign a 21-day waiver. I submitted that to the court yesterday to move the prelim from tomorrow. But he does have some bond violations he needs to be arraigned on as well. So I'll be sticking around to do that.
Do you want us to get him in a Zoom room right now?
Yeah, we could. I spoke to him yesterday, so he should be all ready to go.
All right, we'll do that. Let's go off the record.
Thank you.
What about Ms. Atmar? No, I just texted.
All right, are you Mr. Gomez?
Yes, sir.
All right, so we're here in a couple files, 24-120 FY and 24-152 FY. One's up just for a probable cause conference. I've signed a stipulation from your attorney, Mr. Kukuski, and the prosecutor to adjourn the prelim in that case to April 11th at 10:30. But in both those files, I have to tell you, Mr. Gomez, it's alleged that you're in contempt of court for violating conditions of the court's bond order by having contact with the victim in the matter and that seemingly repeatedly. You are able, there's three of them filed in the 120 file and one of them filed in the 152 file, but they all stem from alleged contact in violation of the no contact order. You have the right to have a hearing on that allegation where we need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in contempt, you could be jailed up to 93 days and or fined up to $7,500 or both. And Mr. Kukuski, with Mr. Gomez being advised of his rights and the penalties, do you know, does he want to set for a hearing?
At this time, we would, Your Honor. I did just receive the most recent, I guess, contempt of court violation. We wanted to vet those things out. We did discuss the matter yesterday. That's when he signed his 21-day waiver, so we could move the exam for tomorrow. So he's fully aware of the possible penalty and that we're going to proceed forward, looking into the matter and requesting a hearing at this time.
All right, so Mr. Gomez, I'm going to enter a plea of not guilty on your behalf to all the contempt citations and set all four of them on for a contempt hearing on April 11th at 10:30. So where we're at is on file 120. We have a prelim and 3 contempt citations on April 11th at 10:30. In file 152, we have a probable cause conference April 4th, prelim April 5th, but the contempt is scheduled at the same time as the others, April 11th at 10:30. All right, anything further, Mr. Kukuski?
Not at this time, Your Honor. Thank you.
Your Honor, I guess due to the nature of the violations and the number, I'd ask that the bond be revoked on the 152 file. I know that he's, I guess I don't have a note on on where his bond is at right now. Mr. Juliet did the other files, but I think due to these violations and what's alleged, I think that the bond being revoked is appropriate.
All right, there is, it was a pretty high bond set. Looks like in both of them, it'd be unlikely to be posted in any event, but I guess due to the nature of the allegations and the repeated alleged violations, I will enter an order in both files revoking bond until further.
Okay. It's also just for the court's information, my understanding, he's on a parole as well. It could be potentially there. So very good.
All right, thank you.
Thank you.
Efficiency. This is, huge. I swear people. Long fast. I suppose that's fair. Into a felony. No, so he did the judge proceed or judge was not? Because I know some district judges will do that. Doesn't matter.
I can't remember. I can't remember.
Some judges. Very interesting. I mean, I always do, I think it's required for sure.
Yeah, I know Judge Visna does in probate because the kids don't always know which hand is which.
It's not required for this. And he's still here. All right, we're back on the record in the Indiana District Court, and we are providing public access both in the courtroom and also online. We're here for a pretrial in 24-067 SD. Dylan Ant. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Sir Brian Clean on behalf of Dylan Ants. Set the podium right for purpose of plea.
All right. And do you have an agreement?
We do. Mr. Ants contender plead guilty to operating while visibly impaired. And there's an OWI reimbursement of
$57.86.
$7.86.
Okay. All right, and Mr. Ants, impaired driving is a misdemeanor punishable by up to 93 days and or $300 fine, cost of prosecution, emergency response, community service, and possible vehicle immobilization and rehabilitative programs. Do you understand the maximum penalty you could face?
Yes, Your
Honor. And did you read and understand the advice of rights form? Did he sign one of those today or no?
He signed one previously. I don't know if he signed one today.
That's fine. I'll just tell him. So Mr. Ants, you understand you've got the right to have a trial by judge or jury and to be presumed innocent, require the prosecutor to prove the guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses against you, to present witnesses in your own defense, testify in your own defense, or to remain silent and not have your silence used against you. Do you understand those rights?
Yes, sir.
Do you understand if you plead guilty, you give up those rights?
Yes.
Is that what you wish to do today?
Yes.
The plea agreement provides in exchange for that plea, prosecutor will dismiss the principal charge, and there's an OWI reimbursement agreed upon in the amount of $57.86. Do you understand that plea agreement?
Yes, Your Honor.
Has anybody promised you anything else?
No.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes.
Mr. Clay, are you aware of any promises, threats, or inducements?
I'm not, sir.
Ms. Miller?
No, Your Honor.
All right, Mr. Ants, knowing all these things, how do you wish to plead the charge of operating while impaired?
Guilty.
And were you operating a motor vehicle on January 24th of this year on McMichael Road, a public highway in Sheboygan County?
Yes.
Before you did so, had you consumed alcoholic beverages?
Yes.
Did you have some contact with law enforcement?
Yes.
Did they give you a test to determine the level of alcohol in your body?
Yes.
Do you remember what the results of that test were?
I'll just tell the court. It was a data or intoxicated 9,000 test. The subject 1 was a 205, subject 2 was a 177, subject 3 was a 204, all of which are above a 0.08.
Okay, and Mr. Ants, do you have any reason to contest that you were above the legal limit there?
No.
All right, Mr. Clayton, you satisfied with that factual basis?
I am.
All right, Ms. Wall.
All right, Mr. Ants, I find that your plea is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis, in fact, in law to believe that you're guilty of that offense. So I'll accept your plea. You can schedule sentencing for April 12th at 10 a.m. You'll have to, if you haven't already, obtain a substance abuse assessment, provide a copy to the court before then, and fill out a form for the probation department so they can make some recommendations. Now, you would typically have, you do have the right to be sentenced by the judge that accepted your plea. This will be scheduled for sentencing in front of Judge Michael Ekdahl, who's assuming office this coming Monday. Mr. Clayton, is there any defense objection to sentencing in front of Judge Ekdahl?
I don't have one. Do you have one, Dylan?
No.
All right. And also, Mr. Clayton, while we're here, do we want to address next week's show cause?
Yes, okay.
All right, so Mr. Ants, it's also alleged that you're in contempt of court for a bond violation for testing positive for codeine. You have the right to have a hearing on that allegation where that would need to be proven beyond a reasonable doubt, and the right to the assistance of your lawyer at that hearing. If you are found to be in contempt, you could be jailed up to 93 days and or fined up to $7,500 for both. The court can revoke your bond if it believes you're not complying with the conditions of it. And so, Mr. Clayton, would your client like that set for a hearing?
Yes, please. Enter a plea of not guilty, set for a hearing on the 12th as well, please.
All right, so we'll enter a plea of not guilty on the contempt, and we'll schedule it for a hearing on April 12th at 10 a.m. as well. All right, anything further, Ms. Miller?
No, Your Honor, thank you.
Mr. Clayton?
No, sir. Thank you.
All right, have a good day, sir.
Thank you.
See you tomorrow. Wow. I'm sure. So.
All right, so we're back on the record and we have People v. Anthony Morris up for a final pretrial 23-850 OM. And Mr. Hungerford's here for the city. Mr. Wergo, on behalf of the defendant, where we at on the final pretrial?
Your Honor, I contacted Hingham County, and when I did, he wasn't there. So there were three counties. One was Oceana, and the other one was where Holland is located. So I guess what happened is that he was transferred from I believe Hingham County back to, I'm not sure whether it's back to Oceana or that. So I think I can reach him. I think I can reach him there. It's my understanding he's got a trial that's scheduled, I believe on the 21st of next month. So what I'll do is I'm going to try to set up a hearing via Zoom. And I know that you're going to want to talk to him prior to that, won't you?
Yes.
Yeah. Okay. And I'll do it as quick as I can.
Okay, well, we could continue the final pretrial then to the next date I've got is April 11 at 11 a.m.
That's fine, Your Honor.
Okay. All right, well, let's do that.
Okay.
Mr. Wergo, they've got Mr. Thompson.
Okay, we'll see him.
Are you Mr. Thompson? Can you hear me? Yeah, I think he's muted on there. All right, so next we've got People v. William Ray Thompson, file 23-0650 FY. And in that file, it looks like we have a probable cause conference as well as a contempt hearing for failing to test and failing to appear then back in fall of 2023. So Mr. Wergo, do you know how we're proceeding on the PCC and contempt?
Your Honor, we don't have any resolution. Mr. Thompson does want to run as preliminary. So for the PCC, we would just ask to have it marked as held, and then we'll go ahead and proceed to the preliminary. And then on the contempt, we would plead not guilty, Your Honor.
Well, I think that was already arranged. That was already, he's already been arraigned on that. So it is up for a prelim tomorrow at 10:30 a.m. We'll leave that on. And we'll continue the hearing till tomorrow then at that date and time, tomorrow, 10:30, and the contempt hearing. And oh, I'm sorry, and there's a PCC. Oh, okay, hang on. And then there's, sorry, I didn't see, there's two files. Then in 124, that was up for a probable cause conference as well. And the arraignment on the show cause. All right, so that's the same issue, contempt, 93 days, $75, $100 fine. We'll plea of not guilty on his behalf on that. So we'll leave that, we'll leave both of them on for prelim tomorrow morning, 10:30 then?
Yes, Your Honor.
And contempt hearing in both files tomorrow morning, 10:30 then.
Thank you, Your Honor.
Okay. All right, we'll see you tomorrow morning, Mr. Thompson.
Thank you.
Oh.
All right, we're back on the record, the 89th District Court for the County of Sheboygan, and next we've got People v. Danielle Atmar, file 23-0772 SD. Council, you want to state your appearances?
Good morning, Your Honor. Paige Miller on behalf of the people.
And good morning again, Your Honor. Luke Custy on behalf of Ms. Atmar.
All right, and we are here for final pre-trial.
That is correct, Your Honor. At this time, I think we're very close to a resolution. I did kind of come in on this thing late. I think my appearance was filed on the 21st of February. This has been my first time to discuss the matter and kind of get information for the prosecutor. I'd just be requesting one more final pretrial, Your Honor. I think there's some information I'd still like to provide to the prosecutor's office.
Okay, well, we'll, any objection to that, Ms. Miller?
No, Your Honor, that's fine.
We'll continue this then to April 11th at 10 a.m.
Thank you, Your Honor.
Thank you.
Does that conclude your matters today, Mr. Christopher?
I believe it does, Your Honor.
All right. Great day.
Thank you, and you as well.
Back on the record, and let's see, we got. Good morning. What is your name, sir?
Chad Arnold Cool.
All right. This is People v. Chad Cool. It's file 23-096 SD for probation violation hearing, Mr. Gilbert.
So that's absolutely correct, Your Honor.
How are we proceeding?
There seems to be 4 issues, and my client wishes to plead guilty to each of the 4 violations.
All right, Mr. Cool, you understand you have the right to have a hearing where the alleged would need to be proven by a preponderance of the evidence, and you have the right to the assistance of your lawyer to present evidence in your own defense of that hearing. Do you understand that?
Yes, Your Honor.
And you're on probation for what?
Impaired driving, Your Honor.
Okay, you're on probation for an impaired driving. That's a maximum of 93 days in jail. Do you understand that?
Yes, Your Honor.
Has anybody promised you anything in exchange for your plea guilty to violating probation?
No, Your Honor.
Has anybody threatened you?
No, sir.
Is it your own free choice to enter that plea?
Yes, sir.
Knowing all that, how do you wish to plead to being in violation of probation?
Guilty, Your Honor.
And you're on probation to this court for impaired driving, is that correct?
Yes, Your Honor.
As part of your probation, were you required to do 30 hours of community service within 60 days?
Yes, Your Honor.
Did you fail to do that?
I have it almost done, but a few hours, sir.
Okay, but you didn't get the 30 done, is that right?
No, sir. I'm like 4 hours off.
Okay. And as part of your probation, you were not to use or possess alcohol, is that correct?
Yes, Your Honor.
And did you use alcohol in late April of 2023?
I did, Your Honor.
Okay, and as part of your probation, were you not to use marijuana?
Yes, Your Honor.
And did you use marijuana in violation of your probation?
Yes, Your Honor.
And it looks like then there was a probation violation arraignment back in May of 2023. Did you fail to appear at that arraignment?
Yes, Your Honor.
All right, Mr. Gilbert, you satisfied with the factual basis?
I am, Your Honor. Thank you very much.
Ms. Miller?
I am as well.
All right, Mr. Cool, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to find you in violation of your probation. So I'll accept your plea. How do you want to proceed, Mr. Gilbert?
Your Honor, I just point out a few things is that he's currently incarcerated. However, prior to that, he was incarcerated in another jail from February 8th. I would ask the court to possibly consider time served.
Okay. When was he arrested on this warrant? March 1st. All right, Mr. Cool, is there anything that you want to tell me or no?
Your Honor, I do belong part of Honor Community Health out of Oakland County, which I am getting my mental health in order and in check. I've been clean now almost 2 years and 30 days off heroin and fentanyl. And that first year has been really tough on me. I mean, I became homeless and I had a lot to do with I wasn't honest with my mental health, so I did seek outside help to get myself in order.
Thank you. Ms. Miller, any recommendations?
Your Honor, I do note that he's been incarcerated since March 1st. I think, you know, it's concerning that there are these violations when he's on probation for the impaired charge. But I think that the approximately 2 weeks that he served is probably appropriate.
All right, well, Mr. Cool, you were on probation to this court for a drinking and driving offense. And while on probation, didn't do the community service as ordered. Continued to use alcohol in violation and then blew off your probation and absconded on it. So I'm going to revoke your probation and no, that other than catching a new drunk driving conviction, that's about as poorly as you can do on a drunk driving probation. So I'm going to order that you do 60 days jail. I mean, give you credit for 4 days that you served originally, plus the 14 you've been sitting. So you're sitting on 18 days credit, but I'm giving you 60. You can appeal to the circuit court if you wish within 21 days and ask for a lawyer within 14. Good luck, sir.
Thank you, Your Honor. My last matter, Your Honor, is Miss Jackson.
Okay, I'm going to terminate the live stream for that.
CC for Luciana Tanicali.
I was told.
Thank you very much.
And then I also had you in for CC on Moffitt.
That deals with the same situation, Your Honor, in the jail, so we had to find another attorney, and I believe Mr. Philippa is taking that case over.
Okay.
Is that staying on for prelim tomorrow then?
I'll have to check with Mr. I doubt it, because he's just coming on.
Yeah, so we may need a stip on that then or something, or we can just address it tomorrow morning, but, so we'll leave. Yes, so you can't speak on her behalf to adjourn that, so we'll leave the prelim on tomorrow at 10:30 a.m. But we'll take the PCC off.
Thank you very much, Your Honor.
All right, Mr. Gilbert, do you have anything else or no?
I think I'm set, Your Honor. Thank you.
Mr. Wergo, do you have one ready?
Several, Your Honor.
Your pleasure.
First one I have up on my list, Your Honor, is Alex Brown.
Okay, people be Alex Brown, file 24-044 SD, up for final pretrial. What's our status here?
Your Honor, we have been in negotiations with the prosecution, and we have reached an agreement. That agreement has been reduced to writing. If I may approach, Your Honor, I have the plea agreement as well as a signed advice of rights.
All right, Mr. Brown, operating while impaired is a misdemeanor punishable by up to 93 days and or $100 to $300 fine. The court can order reimbursement for emergency response and cost of prosecution, can order community service, rehabilitative programs, and vehicle immobilization. Do you understand the maximum penalty?
Yes, sir.
Did you read and understand the rights listed on the advice of rights form?
Yes, sir.
And you signed that form?
Yes.
You have a question for me about any of those rights at all?
No.
Do you understand if you plead guilty, you give up those rights?
Yes.
Is that what you're choosing to do today, sir?
Yes.
The plea agreement provides an exchange for your plea to impaired driving, an agreement to pay a OWI reimbursement of $225. The prosecutor will dismiss the principal operating while intoxicated charge. Do you understand the terms of that plea agreement?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you to make you plead?
No.
Is doing so your own free choice?
Yes.
Mr. Wergo, are you aware of any other promises, threats, or inducements?
None, Your Honor.
Ms. Miller?
No, Your Honor.
Hey, Mr. Brown, knowing all this, how do you wish to plead to the charge of operating while impaired?
Guilty.
Were you operating a motor vehicle on North Mackinac Highway, a public road in Sheboygan County on January 17th of this year?
Yes.
Did you end up having some contact with law enforcement?
Yes.
Before you operated that vehicle, had you consumed alcoholic beverages?
Yes.
When you had contact with law enforcement, did they give you some tests to determine the presence and amount of alcohol in your body?
Yes.
And looks like there was a PBT of a 0.11, is that correct?
Yes.
You agreed that you were over the legal limit?
Yes.
Mr. Wergo, you satisfied with that factual basis?
I am, Your Honor.
Ms. Miller?
I am as well.
All right, Mr. Brown, I find that your plea is knowingly, voluntarily, and understandingly made, and that there is a sufficient factual basis to accept that plea. So I will accept the plea. We can schedule it for a sentencing on April 12th at 11 a.m. And you'll have to complete a substance abuse assessment if you haven't already before that date. Write a copy to the court and check in at the court window. They may have some stuff for you to fill out before the sentencing as well. The only other matter is, Mr. Brown, you would have the right to be sentenced by the judge that accepted your plea. However, it would not be my intention to sentence you. I've been filling in while there's been a judicial vacancy. That vacancy has been filled, and Judge Michael Ekdahl will be taking the bench on Monday. This will be scheduled for a sentencing in front of him unless you object. Mr. Wergo, does the defense have any objection to it?
Judge Ekdahl will be fine with us, Your Honor.
Okay. All right, anything further, Mr. Worker, on that file?
Nothing, Your Honor.
Ms. Miller?
No, Your Honor.
Okay, Mr. Brown, so check in at the courtroom.
Thank you.
And then we've got a initial pretrial in People v. Madison Hilliker, file 24-075 ST. What's our status on this one, Mr.?
Your Honor, the prosecution and defense have reached an agreement on this. It has been reduced to writing, if I may approach, Your Honor. I'm providing the court with the written plea agreement as well as a signed advice of rights.
And Ms. Hilliker, driving on a suspended license is a misdemeanor punishable by up to 93 days in jail and or a $500 fine and vehicle immobilization. Do you understand the maximum penalty?
Yes, Your Honor.
Did you read and understand the rights listed on the advice of rights form that you signed?
Yes, Your Honor.
Do you have any question about any of those rights at all?
No, Your Honor.
Do you understand if you plead guilty, you give those rights up?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes.
The plea agreement provides in exchange for your plea to the charge, there's a sentence agreement for immediate sentencing to fines and costs only. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you to make it?
No, Your Honor.
Is doing so your own free choice?
Yes, Your Honor.
Mr. Worker, are you aware of any other promises, threats, or inducements?
None, Your Honor.
Ms. Miller?
No, Your Honor.
All right, so Ms. Hilliker, knowing all these things, how do you wish to plead to the charge of operating with a suspended license?
Guilty.
On January 24th of this year, were you operating a motor vehicle on M33, a public highway in Sheboygan County?
Yes, Your Honor.
And was your driver's license suspended?
Yes, Your Honor.
Why was it suspended, do you know?
No.
You don't know why it was suspended? You had some contact with law enforcement?
Yes.
Do you know what the status of your license is today?
I'm assuming still suspended.
Okay, did you have a restricted license back in 2021?
Yeah, and I tried to pay the reinstatement fee, but they wouldn't let me. It said it was my license. It said, Secretary of State said my license was valid.
Okay, then you had a re-examination in October 2022. Remember that?
I think I tried to do that, or I didn't finish going through it.
Yeah, and at that hearing, they continued a suspension for you. Okay. All right, Mr. Wergo, you satisfied with the factual basis?
I am, Your Honor.
Ms. Miller?
I am as well.
All right, Ms. Hilliker, I find that your plea is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I'll accept your plea. Anything as to sentencing, Mr. Wergo?
Your Honor, I would just ask that the court follow the agreement.
Ms. Hilliker, is there anything more you want to tell me about this?
No.
Ms. Miller, any recommendations from the people?
Your Honor, Ms. Hilliker is 24 years old with an address in Sheboygan. I do see a prior 2023 allowing DWLS, which was originally charged as a DWLS, so that was reduced for her. I'd ask the court to follow the sentence agreement for fines and costs only, but this problem is just going to continue to happen to Ms. Hilliker if she continues to drive without addressing the issue. Thank you.
Sure, okay. All right, well, Ms. Hilliker, I will follow that plea agreement, and there's a $100 penal fine, $200 in court costs, $50 fee to the state, $75 crime victims fee for $425 total. If you're not able to pay that in full today at the window, you can fill out some paperwork to set up a payment plan. I won't put you on probation or give you to jail. I will tell you, looking at that driving record, it's surprising to me that you would have any question about your license being suspended. It is pretty firmly suspended, and you've got to jump through a lot of hoops with the Secretary of State to get it back. And you've already gotten, a couple breaks now on suspended license, so your license is toast until the Secretary of State gives it back to you. You gotta prove a lot of things to them for that. So you gotta not be driving, or you're gonna rack up a lot of these things.
I know,
Very expensive.
I'm starting to, gonna go to Secretary of State and figure things out.
Okay. All right, so we are entering a judgment, so if you want to appeal from that, you have to file an application to the circuit court within 21 days. If you want us to give you a lawyer, you have to ask within 14. Okay, so check in at the court.
All right.
Good luck. All right, and people be Douglas Boda, file 24-078. So we're here for the trial.
Yes, Your Honor.
Where we at on this case?
Your Honor, the prosecution and defense have reached an agreement that has been reduced to writing, if I may present to your bailiff.
Okay.
As well as we are presenting a signed advice of rights form for Mr. Boda.
All right, Mr. Boda, driving on a suspended license first offense is a misdemeanor punishable by 93 days and or a $500 fine and vehicle immobilization. And failing to report an accident is misdemeanor punishable by 90 days and or $100. Do you understand the maximum penalty you face?
Yes, Your Honor.
Did you read and understand the rights listed on the advice of rights form?
Yes, sir.
And you signed that form today?
Yes.
Do you have any question for me about any of those rights at all?
No, Your Honor.
Do you understand when you enter a plea, you give up those rights?
Yes.
Is that what you wish to do today?
Yes, sir.
The plea agreement provides in exchange for your plea to the charges I outlined, the prosecutor will dismiss the second offense notice, the 1-year misdemeanor. Do you understand that plea agreement?
Yes, sir.
Has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is entering that plea your own free choice?
Yes, sir.
Mr. Virgo, are you aware of any other promises, threats, or inducements?
I am not, Your Honor.
Ms. Miller?
No, I'm not.
All right, Mr. Boda, knowing all these things, how do you wish to plead to the charge of operating on a suspended license?
Guilty.
How do you wish to plead to the charge of failing to report an accident?
Guilty.
So on or about December 1st of 2023, were you operating a motor vehicle on Chippewa Beach Road, public highway in Sheboygan County?
Yes, Your Honor.
Was your driver's license suspended?
Yes.
Do you know why it was suspended?
I believe it had to do with prior convictions.
Okay. And did you have some collision with that vehicle?
Yes, vehicle backed into my vehicle.
Okay. And did that result in damage of $1,000 or more?
Yes, Your Honor. It was my father's truck, and the person that was backing out of his driveway was slipping on ice, caught traction, and slammed into the side of my father's vehicle.
Okay. And did you fail to report that accident to the nearest or most convenient police station?
Yes, Your Honor.
All right, Mr. Virgo, you satisfied with the factual basis?
I am, Your Honor.
Ms. Miller?
I am as well.
All right, Mr. Boda, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So if I accept your plea, give me 1 second just to review the affidavit here. Could counsel approach, please? All right, so we're back on the record, and Mr. Boda, I just wanted to confirm based on my review that I didn't have, it looked like we didn't have any indication that you were drinking that night. I wanted to confirm that, counsel. So we'll go ahead and proceed with sentencing. Mr. Wirgo, anything you want to say on your client's behalf?
Just your honor that Mr. Boda has owned this. He showed up. He's ready to go ahead and do this. We would ask that the court limit sentencing to fines and costs of potential work group.
Thank you. Mr. Boda, is there anything more you want to tell me about this or no?
Well, I'm working on getting my license back. I do not want to be in this situation again. So I'm working with a tribal attorney to get my license back.
All right, thank you. Ms. Miller, any recommendations from the people?
Yes, Your Honor, Mr. Boda is 47 years old with an address in Indian River. I do see a criminal history, including 7 prior misdemeanor convictions, including 2 prior convictions for driving while license suspended, 1 in 2019 and 1 in 2013. Mr. Boda was driving with his license revoked on this date, and there was a crash between him and another vehicle. The most important part in getting your license back is to not drive while you're doing it so that there's no further setbacks. And unfortunately, Mr. Boda did do that due to his history and the fact that there was a crash. I would ask that the court order 2 days of the work crew. Thank you.
All right, well, Mr. Boda, I mean, your license is revoked for some prior drinking and driving convictions, and but you weren't drinking on this occasion, so that's good. But there was a collision, and then you requested the person to not call the police. You know, those are, you know, we don't like to give jail for suspended license cases, but you're dancing on that boundary. But I think at this point, I'm going to go ahead and assess fines and costs and some work per days. So on the DWLS, be $100 penal fine, $200 court costs, $50 justice system fee to the state, $75 to the crime victims fund for $425. And actually, in the failing to report the accident, has an additional $50. There's one for each count. I'm not going to assess any additional fine or court costs on that. So that's a total of $475. If you can't pay that today, you can fill out paperwork for a payment plan with the court. I'm also going to order that you complete 2 days on the sheriff's work crew program within the next 45 days and provide proof to the court that you've done so, or you'd be held in contempt. So I'm not going to place you on probation for that, but you face contempt if you don't complete it. The court window could give you information about how you get that set up. And if you wanted to appeal, you'd have to file an application to the circuit court within 21 days. If you want us to be your lawyer, you'd have to ask me within 14. You have any questions for me, Mr. Boda?
No, Your Honor.
Good luck.
Thank you.
Then we've got People v. Montana LaHaye, file 24-117 SM. So what's our status in this matter, Mr.?
Your Honor, the prosecution and defense have reached a agreement that has been reduced to writing, if I may approach and present to your bailiff. And Your Honor, I've also presented to the court a signed advice of rights for Mr. LaHaye.
All right, Mr. LaHaye, assault is a misdemeanor punishable by up to 93 days and or a $500 fine. Do you understand the maximum?
Yes, sir.
Did you read and understand the rights listed on the advice of rights?
Yes.
Can you sign that?
Yes.
Do you have any question for me about any of those rights? Do you understand if you plead guilty, these are the rights that you give up?
Yes.
And is that what you're choosing to do today?
Yes.
The plea agreement provides in exchange for your plea to the assault, there's a sentence agreement for a delay of sentence. And during that delay, you'll be subject to some probationary terms. If you successfully complete those terms, then the charge will be dismissed. Do you understand that plea agreement?
Yes.
Now, that sentence agreement is not binding on the court, meaning at sentencing, if the court didn't want to follow it, it wouldn't have to. But if the court did not give you that delay of sentence, you'd be allowed to withdraw your plea. Do you understand that? Meaning that there's an agreement between the prosecutor and the defense that you get a delay of sentence. That agreement does not include the court. So the court doesn't have to go along with it. But if I didn't, or if the judge at sentencing didn't, you wouldn't have gotten what you bargained for, so you could withdraw from the agreement. Do you understand that?
Yes.
All right, I mean, do you want to talk to your lawyer some more about that?
If I may speak.
Sure, no problem.
We're all set, Your Honor.
Oh, do you understand that, Mr. LaHaye?
Yes.
Now, there is a very important exception to that rule. If between now and the sentencing date, you do something stupid like commit a new crime, or not show up for court, or violate your bond conditions, then all bets are off. And the court doesn't have to give you that delay, but your misconduct would mean you lost the right to withdraw the plea.
Yes.
Other than that plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you?
No.
Is doing so your own free choice?
Yes.
All right, Mr. Wergo, are you aware of any other promises, threats, or inducements?
None, Your Honor.
Ms. Miller?
No, I'm not.
Mr. LaHaye, then, knowing all these things, how do you wish to plead to the charge of assault on a Michael Decker?
Guilty.
Mr. Wergo, would you assist with the factual basis of this?
Sure. Mr. LaHaye, do you recall an incident on or about February 17th of this year?
Yes.
And you were in the hospital at that time, is that correct?
Yes.
And do you recall a security guard, Mr. Decker, and you having a physical altercation?
I can't really remember.
May we approach then, Your Honor?
Sure. All right, so based on lack of memory due to, looks like some intoxication, Ms. Miller, do the people have any objection to the tendering of a no contest plea?
No, Your Honor, I think it's appropriate.
And Mr. Wergo, is that how the defense wishes to proceed?
Yes, please, Your Honor.
Okay, so Mr. LaHaye, then how do you wish to plead to the charge of assault, guilty, not guilty, or no contest?
No contest.
All right, and I have reviewed the affidavit of probable cause. It does indicate that while Mr. LaHaye was under a state of intoxication, requiring hospital evaluation, he became agitated, and when hospital staff directed or attempted to redirect him to not leave, he did physically assault the hospital staff. So I'm going to find, and that occurred in Sheboygan County. So I am going to find that there's a sufficient factual basis for that offense. Mr. Wergo, do you concur that a factual basis has been established?
I do, Your Honor.
Ms. Miller?
Yes, I do.
All right. So, Mr. LaHaye, I find that your plea is knowingly, understandingly, and voluntarily made, and that there's sufficient factual basis in fact and law to believe that you're guilty of that offense. So I will accept your plea, and I'm going to schedule sentencing for April 12th at 11 a.m. I think given that this was, did have some controlled substance involvement, I'm gonna direct Mr. LaHaye obtain a substance abuse assessment before sentencing. Provide a copy to the court. Mr. LaHaye, you would have the right to be sentenced by the judge that accepted your plea. But I'm not the district judge, I'm the circuit judge, I've been filling in. The district judge is assuming office on this coming Monday. So this would be scheduled in front of Judge Acdahl, the new district judge, on April 12th. Unless you object, and we can schedule it in front of me. Mr. Virgo, do you know if the defense has any objection to sentencing in front of Judge Acdahl?
None, Your Honor.
All right, so it'll be sentencing in front of Judge Acdahl. All right, so check in at the court window. They'll have some stuff for you to fill out. Okay, Mr. Wilson. That conclude your matters, Mr. Virgo?
Other than there was a PCC for a Liz Burcham, Your Honor. I did try and fax over the waiver. Okay. Then yes, Your Honor, I believe that concludes everything for me today.
And Your Honor, I know we discussed Moffitt earlier with Mr. Gilbert.
I see Mr. Flippin.
Yeah, so I think that he wants to address it.
Good morning. What is your name?
Jessica Manson.
Place you back in the waiting room for a minute. See Mr. Gilbert. Waiver of the PCC or not? Well, that's weird. I see.
I haven't received an appearance.
Oh, yeah, no, it's Gilbert. Mr. Filippo, are you there?
I am here, Your Honor.
All right, we had earlier addressed Ms. Moffitt on the record, although she was not present. Mr. Gilbert advised that you were taking that case over. And so all we did was say, well, we'll leave it on for the prelim tomorrow. Is there anything different that you want to do?
You know, without her present, I'm not sure it's possible to waive 21 days. I'm not sure if the court would be willing to, for good cause, waive 21 days with.
I would find good cause for an adjournment, even absent a waiver, because there was a conflict of interest due to co-defendants. And so Mr. Filippo is just into the case too recently to be adequately prepared for prelim tomorrow. So so I would adjourn the prelim then to April 5th at 10:30 a.m.
Would the court, instead of scheduling that as a prelim, perhaps set that as a second probable cause conference?
Oh, you know what? Actually, I should probably set that for, they've got it set, the dates I'm supposed to give would be a PCC on April 4th. And then the prelim the next day. So we can do that. We'll set it for a probable cause conference, April 4th at 10:30. Is that okay, Ms. Miller, for the prelim to be the very next day? Because that doesn't really.
It doesn't help us much with scheduling.
Subpoenas. All right, well, we'll put it on for a probable cause conference on the 4th and a prelim on the 12th, 10:30 both days.
Thank you.
All right, Mr. Filippo was having some connection problems, but I granted what he's requested. I find good cause for the adjournment.
Judge, I heard all of those. Would it be possible that the PCC would be on the April 5th date instead of April 4th? Just with some issues in my own scheduling.
You betcha. So probable cause conference, April 5, 10:30 a.m. Prelim, April 12, 10:30 a.m. All right, thank you, Mr. Flipper.
You're welcome. Thank you, Judge.
Right, and then let me look at this Manson here. I think that's, let's go off the record for a second. All right, we're back on the record and Ms. Manson, we're here in file 24-122 FY. And Public Defender's Office has had to get attorney from out of town to represent you in this matter, Mr. Dobiash. He's not able to be here today. So Mr. Vargas is here on your behalf. And we're scheduled for a probable cause conference today and a prelim tomorrow. Mr. Varga, how are we
Yes,
proceeding?
Your Honor. Coincidentally, I did speak with Mr. Dobiash yesterday. And this case did come up. Mr. Dobiash did tell me he was going to represent Ms. Manson. I spoke with her briefly this morning. She indicated she had a phone conversation with Mr. Dobiash yesterday. And they have not decided whether or not to waive preliminary examination. So at this point in time, I asked the court to schedule preliminary examination, but adjourn the preliminary examination, which is currently scheduled for tomorrow, to a date in the future. She's going to wait the 21-day rule.
All right, Ms. Manson, do you understand you would have typically have the right to have the preliminary examination within 21 days absent the court finding good cause to adjourn it? Do you understand that?
Yes, sir.
Do you agree that there's good reason to adjourn it so that your new attorney can get up to speed with you on it?
Yes, sir.
All right, so the court would also find good cause and find a waiver placed on the record. And we'll schedule this for a probable cause conference for April 5 at 10:30 a.m. and a prelim on April 12 at 10:30 a.m. during the date from tomorrow. All right.
Thank you very much.
Thank you, Ms. Manson. You have a good day.
Thanks. You too.
I'll conclude our dockets.
And go through Mr. Alexander and the. I'll be right up to talk to him.
Okay.